So a trust is essentially a contract between three people. The person who creates the trust, that person is referred to as the trust maker. You'll also hear that person referred to as a grantor, a settlor, or a trustor. So that's the person who creates the trust, creates the terms of the trust, and then puts property or assets into that trust. The second party to a trust is called a trustee. A trustee receives the trust assets from the trust maker, and then the trustee controls those assets. Now, they must use those assets to benefit what the third party is, a beneficiary. So the trust agreement would describe the terms for how the trustee is to manage the assets for the beneficiary, and then ultimately how those assets would be distributed. There's two primary types of trust: a revocable trust versus an irrevocable trust. The difference between the two is a revocable trust can be amended or revoked during the lifetime of the trust maker. Whereas once an irrevocable trust is funded and created, the terms of that trust are set in stone. It can't be changed. A revocable trust is the primary instrument that people use in creating an estate plan. So they would create a revocable living trust. It's also referred to as a living trust, a family trust. There's a whole number of other terms you may have heard for a revocable trust. But that trust is created and funded by the trust maker. The trust maker is also the trustee and the beneficiary. And then throughout the lifetime of the trust maker can amend that revocable trust to provide for changes which happen during their life when the trust may no longer suit their needs or estate planning wishes. Irrevocable trusts are trusts that are used for a number of purposes. It could be asset protection, it could be charitable giving, it could be tax planning. But once an irrevocable trust is created, it cannot be changed by the trust maker. A special needs trust is established to provide benefits for a person who may be disabled. The purpose in creating the special needs trust is to provide benefits to that special needs beneficiary so that the special needs beneficiary doesn't lose any government benefits that the person receives. There's two types of special needs trust: a first person special needs trust and a third person special needs trust. The primary difference between the two of those types of trusts is in the first party special needs trust. That's a trust that's actually created by the disabled beneficiary and funded with that beneficiary's own assets. It typically has to be created through a court proceeding, whereas in the third party context, that would be the equivalent of a mother or father setting up a trust, putting the mom or dad's assets into the trust, and the beneficiary is the disabled child. By setting up a third party trust, it doesn't disqualify that child from receiving any benefit programs that they're on, and those assets can then be used to provide for certain expenses and living expenses of the disabled beneficiary. So trusts can also be used for asset protection planning. There's two types of asset protection planning that a person could be concerned with. The first type of asset protection is for the actual trust maker themselves. So is there any way that that trust maker can create an irrevocable trust, put the trust maker's own assets into that trust, and hope to defeat a potential creditor claim, whether that's a divorce, bankruptcy, lawsuit, any one of those claims? In most states in the United States, the answer is no. That's called a self-settled trust, and a person cannot create a trust, fund it with their own assets to defeat potential creditor claims. Now, there are certain states that allow a person to do that, and those states allow for the creation of what's called a domestic asset protection trust, otherwise known as a DAPT. So, Nevada, for instance, allows a person to do that, South Dakota. Here in Arizona, however, Arizona law does not allow a person to create a domestic asset protection trust. The next type of asset protection trust that could be created is for a third person. And when a trust maker creates an irrevocable trust and transfers that trust maker's assets to it for the benefit of a child, the assets that get funded into that irrevocable trust are protected against claims not only from the trust maker, but also claims against that particular beneficiary. And this is important because there could be issues with respect to the beneficiary that need to protect the beneficiary from themselves. So, for example, if you have a child who has a substance abuse problem and you want to provide some care and protection for that child, but you don't want to give them that money outright, then you can put that money into an irrevocable trust with that child as a beneficiary. And then that trustee can use that money to pay expenses for the child. And that way, the money doesn't go directly to the child and potentially end up wasted on, bad things. The trust provides protection for that beneficiary so that money can be used for the duration of their life to care for them. So, another type of trust that people create is a trust to benefit a charity. There's a number of potential charitable trusts that are created to not only benefit the charity, but then there is also tax benefits that can accrue to the trust maker. So, those are trusts that if a person has charitable intent, that we would be happy to discuss further with any potential client. So if you guys have any questions about any type of trust, revocable, irrevocable, what type of trust best suits the needs and goals that you have, feel free to give me a call at any time, and I'm happy to answer those questions and explain any of the different types of trust and estate planning concepts to you.